the Supreme Court of India has observed that and has officially said in a ruling by a special bench that the heir is the only person who has the ownership of shares and debentures, which means successors are the only people who have the ownership of shares and debentures after the death of a person, and not the nominee whose name is mentioned in the share or debenture certificate. This ruling comes from a special bench of the Supreme Court of India, or the Justices Sanjay, Karol and Hrishikesh Roy have said this. And that begs the question. We always keep thinking we have to pick a nominee for all our financial investments, for our mutual funds, for little things. We always pick nominees. So what happens to the nominees? Because according to this judgment, it says that the nominees by default don't get ownership of the shares or debentures. So how do we choose nominees, and why do we choose a nominee if eventually the legal heir who gets the ownership of it all? We have a very special guest joining us as well on the show, by Bijal Ajinkya, partner Khaitan Co, joining us. Bijal, the simple question is that, people like me, Kartik, and all those watching, we've always believed that the nominee is the most important thing, isn't it? Because once you choose a nominee, that means that once after you're passing, you know where your financial wealth goes to. But this ruling makes us rethink that all over again.
Yes. So a nominee has always been nothing but like a trustee to the assets of that particular holder. And to that extent, it is the succession laws which are applicable to that particular individual, which would trump the succession of that particular asset. Now, what is most important is that if at all a person has written a will, to that extent, the whoever is written as the heir in the will be the one who is the real heir or the successor to those particular shares or debentures, and the nominee only has to hold those particular shares as a trustee till the time the probate process or the succession process is complete, and to safely hand it over to the particular heir. So that is really what the legal status of a nominee is, very similar to that of any nomination done in a housing society. So very important that when you are choosing your nominee, the nominee should be a person who you actually want the heirship to go to.
Okay, Kartik, were you able to wrap your head around this? Because the first time I read it, I could not wrap my head around how is the fact that the nominee is still remains important to choose a nominee and to choose a trusted nominee, isn't it? Even after a judgment like this.
Yeah, absolutely, Krishna. I think the question really is, we as a society, as an economy, as banking and financial institutions lay so much emphasis on a nominee when the nominee is actually nothing but a caretaker who is safeguarding your asset until it is transferred, and in fact enabling transfer of that asset to its rightful owner. Now, the question really is that while the Supreme Court has upheld the special division bench of the Bombay High Court's ruling, which was challenged in 2017, the question really arises now is that while the order or the judgment mentions shares and debentures, my assumption is, and I think Bijal would be able to answer that, my assumption is that these rules of nominees are valid for pretty much every financial asset, whether it is a fixed deposit, whether it is a mutual fund, whether it is a saving bank account, whether it is a bank locker, or any other nomination that you put on these certificates or on these nominee certificates. So, Bijal, is this assumption correct, that a nominee, no matter what financial instrument the nominee's name is on, is actually nothing but a caretaker? So even in the case of fixed deposits, if a nominee has been mentioned as a nominee and nothing more, and if the will stroke the succession laws, and we'll come to the distinction between these also, states somebody else as the rightful owner, the nominee's job is to ensure that it is transferred legally to that rightful owner.
Absolutely, you are correct. To that extent, as you rightly mentioned, they are just a caretaker or a trustee to safely hand over that particular asset to the real heir. and it would apply the same for all financial assets. The one which it does not apply to, and the one which essentially the nominee is really the heir, is for insurance policies. But if you're looking at any other financial asset, it is the nominee who's just the caretaker to hand over the asset to the real heir.
Okay, barring insurance policies, everywhere else, this judgment is what everybody needs to keep in mind. My question here is that while arguing this at the apex court of the Supreme Court, Companies Act of 1956 and the further amendment both were used, and in fact, that was used as a prima facie argument to prove that it is the legal heir who will get custody of the shares and debentures.
Absolutely, that is correct. And to that extent, the Supreme Court is just re-emphasizing the law of the land, that the nominee is just a caretaker or a trustee. So it is important that it is borne in mind when you're looking at succession of that particular asset.
So, Bijal, help us understand here, what are the succession laws? How are they different from a will? And what is the order of precedence? To my lay understanding, I would assume that the will would be the first order of precedence. If there is no will, in the absence of a will, the succession laws would come into place, and then you decide who the rightful owner or rightful inheritor is. So, what is the best way then to sort of tide over this challenge of just putting the name of a nominee, assuming that then the onus is on the nominee, he can or she can figure out what to do with your wealth?
Absolutely. So what is important is that in India, succession to assets goes by the religious laws which you are subject to. So to that extent, if you are a Hindu, you follow the Hindu succession law. If you are a Muslim, if you're following the Muslim faith, you follow the Sharia law, and so on and so forth. Now, in India, you have complete testamentary freedom on whom you want to give your assets to, other than under the Sharia law, where you do have a forced heirship. So generally speaking, if at all a person does write a will and writes the heir to that particular share or a debenture as X, the shares or debentures must go to X so long as it is a valid will. If at all a person has not made a will, then in that situation, the succession laws would take effect, and whoever are considered as the class 1 heirs under the succession laws applicable to the deceased would be the one which would decide who is the heir to those particular shares or debentures.
So, who would
Very,
then
very
these,
important to note.
Okay.
Sorry.
Go ahead, please.
Very important to note that for a lot of Indians who do have foreign shares or foreign debentures, not necessarily would you be allowed to actually write the name of a nominee. So to that extent, it would be your succession law or your will, which will be the one which will decide who is the heir to that particular asset.
Just a quick question in the middle of all of this. You're basically saying that if you have shares and debentures in foreign companies and outside of India, then this particular judgment doesn't apply. This applies to all your financial assets that you own within India.
Absolutely, that is correct.
And same with property as well.
Absolutely. And very often people believe that a nomination done in a society essentially is as good as a will, which is not correct at all. And to that extent, a nomination is again nothing but a caretaker or a trustee whose only job is to pass on that particular residential property to the heir as mentioned in the will, and in the absence of the will under the succession laws.
All right, fascinating insights there from Bijal Ajinkya, partner, Khaitan Co. Bijal, my question to you at this stage is, you were talking about the fact that all this latest judgment from the Supreme Court of India doesn't apply to what an Indian citizen owns outside of India, which means shares and debentures held in foreign companies and in properties that this Indian citizen might have invested in. So what happens to all of that in the absence of a will?
Absolutely. To the extent that a will has not been created with respect to that particular shares or debentures in a foreign company, it would be important to note that foreign shares essentially are governed for succession by the domicile of a particular person. Domicile is where you generally live and where your intention is to reside. So, if at all your intention is to reside in India, you are considered of Indian domicile. And to that extent, it would be the succession laws of India which would govern the succession of those foreign shares or debentures.
Okay.
So, which basically means that again, succession laws will kick in for anything, any property or any shares and debentures held outside. All of this talk, Kartik, doesn't it also remind you of the fact that not enough Indians create wills? Not enough, even people keep thinking that wills are meant for extremely ultra wealthy people to manage their wealth, but it's important that even middle class Indians learn to start creating wills.
Absolutely, and I think, Krishna, that is what we started off by discussing, that there is so much emphasis put on nominees. It is almost in equal measure or exactly in equal measure as it is for KYC documents. You've got to have your KYC documents anytime you're opening either a broking trading account, or anytime you're opening a fixed deposit or a salary account, savings bank account, locker. The emphasis is always as much on the KYC documents as it is on the nominee. But I think this explanation of the fact that the nominee is nothing but a caretaker is not done enough. So most Indians, I would assume, would end up believing that I have put the name of the nominee,
yes,
and I will put the name of that person who I want to will that asset to. I think that seems to be the general level confusion when you're putting the name of a nominee. However, it might be prudent then, as I understand, to maybe have a lawyer's name as a nominee to ensure that the rightful transfer, ownership, etc., inheritance is done legally.
Is that a good strategy, Bijal?
Definitely not, I would suggest. More from the perspective
So how
that
the reason why I'm asking is that
does a nominee need to be a blood relative, relation, or a spouse, or
No.
alike as well? Can it be a friend? Can
Be a-
Krishna be on my nomination list,
It can
and vice
be-
versa?
Absolutely. You're absolutely right. It can be just about anyone. It's just important for the holder to recognize that a nominee is not the heir. And as you rightly mentioned, most people believe that the nominee is the one who actually that particular property is going to, and they're all set. So, to that extent, very important to ensure that the nominee is aligned to either your will, or the nominee is aligned to the succession laws which that particular person is subjected to.
And I really want to, help us break this down, and eventually help whoever is watching us right now. That what is the natural succession law? So if somebody, let's say, a 50-year-old, 60-year-old man, married, has 2 children, has maybe one parent alive, just taking a very, very broad sort of a framework of a typical Indian. If the person were to die, then in what order, what property or what assets get transferred using the succession law in the absence of a will to which family member?
So, as I mentioned, succession laws in India are governed by the personal faith which you are following and which you are subject to. So, let us just take an example of a person who is a Hindu, a Buddhist, a Jain, etc., who are all within the ambit of the Hindu Succession Act. Under the Hindu Succession Act, if a Hindu male passes away, leaving behind his mother, his wife, and let us just assume 2 children, the class 1 heirs of a Hindu male who has passed away without a will is his mother, his wife, and his 2 children, all in equal proportion. So, to that extent, if we were to apply it for shares or debentures, each of these 4 would inherit a 1/4 of that particular share or debentures which are held by that particular individual. Similarly, if at all a Hindu female passes away, then her assets essentially go to her husband and her children, all in equal proportion, so long as she has not created a will. So you would need to look at the specific succession law which is applicable to that particular individual to determine as to who the heir to that particular person is.
Is that valid across all asset classes, from property, real estate, to shares, debentures, to lockers, to bank accounts, fixed deposits? Is this sort of division valid across every asset class?
Absolutely. So, be it shares, debentures, banks, bank accounts, real estate, etc. It applies across to all. The only important differentiation is that in an insurance policy, the nominee is the person who actually will get the policy proceeds when the life insured passes away.
All right. So that becomes a beneficiary, so to speak,
Yeah.
not really a nominee.
And I actually liked
Absolutely.
when we asked Bijal, and she said that should a nominee be a lawyer? And Bijal immediately was
No
strike
way.
down the
No
idea.
way.
She said, no,
That
don't put a
ain't
nominee
happening.
as a lawyer. Why so, Bijal?
No, I think it's just important that the family really thinks about whom they're really writing as the nominee, and to that extent, you could have a family member as generally speaking, we would always suggest that align the nominee to the person who is the heir. It just becomes easier. What is important to note that till the time of the deceased, the person having deceased and the probate being received and the asset really passing, the person who is the nominee is the one whose account as a nominee dividends would go to. Or if there is a shareholders meeting and a vote needs to be given, it would be the nominee who would be the one who would actually vote in place of the person who is the heir, because the heir has not yet received that particular asset. So it's just from that perspective that if you're looking at a promoter holding, a family company, and you're looking at who the particular person is voting, you may actually want a family member to vote, and maybe the lawyer or any other professional may not really be in a position to really understand the running of the company. So it was only in that perspective,
Okay.
which is where I said a no.
I just assume that you don't want to get into unnecessary litigation at the wrong time and the wrong stage in life with the wrong person. I was just wondering what will happen in a lawyer's family. How does that work?
Well, Bijal, I have one final question before I let you go. Now, let's assume a contrary theory that there is a person, the same scenario, the same Hindu, male, 60-year-old with these 4 immediate family members who has written a will. And if that will, according to the remaining 4 next of kin to him, believe that, that there has been an unfair distribution of the wealth, then when it gets challenged, if it gets challenged in court, obviously every case would sort of differ from case to case basis, but then at what point do you think the succession laws could come in and proceed over the will?
Absolutely. So if at all there is a contest to a will, and a contest can only be really held on, say, 3 particular grounds under law. So either you can say it is not the signature of the person, you can say this person was mentally incapable to really process what he was writing in the will, or you could say that there was duress which was exercised and he was forced to sign the will in that particular manner. Now, if at all any of these 3 grounds are really filed before the court, till the time the court really provides its final judgment, the assets essentially remain in limbo. The nominee is the one, till the time the litigation is completed, the nominee is the one who will actually vote in a shareholders meeting, will receive the dividends, not for his own benefit, but for the benefit of the heirs to be passed on once the litigation is complete and the court really decides who the heirs to that particular individual are.
Right, Bijal Ajinkya, their partner at Khaitan Co, really decoding the difference between nominees and heirs for us, and in fact giving us an important lesson about the fact that every single time we are choosing nominees, we should think about the fact that we need to choose heirs and then think about who can be the nominee, and be very clear about the distinction between these 2 words. Really, successor and nominee, these 2 are different things. The only place where the nominee is the successor is an insurance policy alone. Nowhere else, in no asset class. Please bear that in mind, and also think about the fact that maybe just you have to draw up a will sooner or later. And with that, we let go of Bijal Ajinkya, partner Khaitan Co. Bijal, thank you so much. Just a joy, pleasure having you on the show, and hope to keep having you here on News 9 Live again and again. But for now, we'll let go of you. Thank you so much for being with us.
Thank you.